Your Honor.
Your Honor, we could take out one new matter just so that we're making some progress, and it's a matter I submitted to Solicitor Gibson and to your clerk a moment ago. I don't know that you even had a moment to look at it, but
I have. Go ahead.
well, Your Honor, we live in kind of a new time, the era of Murdoch. And when I began practicing law in the 70s and the 80s and the 90s, we used a time-honored device in high-profile cases, sequestration of the jury. Now, we did not move for sequestration, nor did you choose to do that, Your Honor, and we respect that decision. But at this juncture, Your Honor, this case has garnered so much publicity, so much, I think I can't understate the polarization in this community about this case, and that's for a variety of reasons that I've submitted to you and would ask to make as a court exhibit several pieces of paper. One is simply a photograph that was posted on Instagram, I believe, and it is one of the more tame. I am told, though I'm not, I don't cruise the internet, certainly not during a trial, but I am told that there are TikTok messages that if there's not a conviction in this case, that the courthouse will burn. I know that that's of concern to everyone. There are, yesterday, the third piece of paper, which is a dark text message, was received by a member of my client's family, and they sent it to me immediately and made no response to it. But it's alarming because it represents the other polar, what I would call the skinhead white supremacist, that lunatic fringe. And, Your Honor, in the middle, as we have said, the narrative in this case, beginning shortly after the incident, hasn't been helped by the statements of public officials. I've attached that, but it's already a part of your record elsewhere. And then I've highlighted a portion of a news article, which I won't read because I've highlighted it for you, but it suggests that somehow this trial, instead of being a fact-finding mission resulting in a neutral, detached jury's deliberation and determination of guilt or innocence, is somehow a moratorium, and that justice will fail if the event that this journalist seemed to suggest is the result that should be obtained. But, Your Honor, for all of those reasons, we rely on judges' instructions. We hope, we keep our fingers crossed that juries will take that to heart, that they will avoid interference, that they will report it to the court. But we know from the Murdoch case, that just doesn't happen. Now, that case is different because it involved the interference of the court official, one who, as our Supreme Court said in that opinion, was the court's representative. So the jurors could have easily felt, as they did in that case, that it was okay because that was the court's caretaker. But I think that there is the very real potential, given the amount of publicity attendant to this thing, Your Honor, that I would ask the court, though it is inconvenient, it will take 10 minutes, and I would not oppose you, Your Honor, going to the jury room and pulling them one at a time out in the hall. I don't know that we even need to be present. I don't know that the prosecution will have a position on this, but I do think it's important not to poll them as a group. I think it merits, in order to assure a fair trial, that is free from any taint, interference, suggestion, even to the extent of driving by the state capitol this week, you're likely to have seen a poster. And I don't want jurors to think that they're getting themselves in trouble if they have seen something that may have caused them to think in an inappropriate way. But I do ask, Your Honor, with all respect for the time and the economy of time, but I think it is that important. Thank you.
State position.
Your Honor, I don't think we need to bring any additional attention to this matter, Judge. I mean, the things that Mr. McCullough has brought out, I mean, I appreciate the fact that he brought it to our attention, but we can't control what the outside world does. And I mean, posts by people who are not involved in this case, that we had admonitions that were given. And to our knowledge and what we know is the family's done everything they're supposed to do. They've not posted, they've not engaged, they've not done any of the things that the court has asked them not to do. What the rest of the world does outside of this courtroom is what the rest of the world does. What the rest of the world calls us, calls prosecutors, I really don't care. You know, we're here to do justice, and that's why we're here now. To ask the jury to do something additional now, Judge, if they've got a question, they have the ability to write it down. They got the ability to say, hey, Judge, this did or didn't occur or whatever. And to my knowledge, that's not taking place. So in order to pull them out and start kind of poking and asking, you know, specific questions of them, I just don't think it's proper at this point. We've had other high-profile cases. We've not done it. We didn't do it in the Uber case here. We didn't do it. I mean, it's not been done that I can recollect from my almost 30 years of practicing law. I've not had a case where that's happened, and I don't think that we need to start doing it now. If the jury has a question, they understand your admonitions. These are grown folks who went through the process. They've adhered to everything that you've asked them to do at this point, and there's no need to start pulling them out and searching for something when they're not telling you that anything is going on. I don't think it's proper right now.
Your Honor, I would simply say that as I mentioned, we sequestered juries for many decades. And we did so at a time when the only access that jurors could have to taint themselves were much less than today. There were 3 TV stations. There was no internet. There was no social media. There were neighbors. And those opportunities were the only opportunities to be tainted by public opinion. And yet, for 3 decades or 4, our courts sequestered juries. To the best of my knowledge, we stopped doing that because of the expense. Okay, I get it. But today, 1,000 television channels, social media platforms that allow the worst and most scurrilous, degrading, disgusting conversations, even to the point of threats of violence and threats of destruction, that is so ubiquitous, Your Honor. And I think, I don't know that I recall making a motion like this, but having gone through the crucible of the Murdoch case, I recognize a couple of things. The frailty of a jury's willingness to come forward. And that's a human nature. It's not a dishonesty on the part of the jury. It's just a belief that it doesn't need to be reported. So I would ask again, Your Honor, while it may be novel, but I think it is necessary. And the mere fact that it hasn't been asked before of you or another judge, whether in this courtroom or another, I don't hesitate or have any embarrassment about asking you to do it now to ensure against the possibility that any juror has been contacted or otherwise stumbled in to the receipt of information. Thank you.
All right, well, I don't know your position on that, Mr. Cole. I don't think there's any real procedure for doing that, and I see it as fraught on a number of levels. If I were to go back there and examine each juror individually myself, again, based on what we learned from the court's ruling in Murdoch, I'm hesitant to have any sort of conversation off the record outside the presence of all the lawyers with any juror. So I will deny your motion in that regard. What I am going to say, though, too, is the stuff here that you provided is troubling, although there's been a lot of troubling things all weekend. Lawyers, and I guess I'm more talking to the public here, we just all need to turn the temperature down, much like I cautioned the lawyers Wednesday to turn the temperature down. The public does too. This matter is actually only a matter of life or death with the Carmack-Belton family and the Chow family. The rest of the folks don't need to be sending messages like this to lawyers. I actually got emails myself over the weekend, which reminds me I need to send a sled. Please, folks, just turn the temperature down. There will be a verdict maybe here today, and we're all going to be respectful of one another. And I want to commend everybody who's been in this courtroom for the week, or all last week. Everyone here has been respectful to one another. There have been no issues, there have been no outbursts, and I commend you all on that for being respectful of your neighbor. But we're going to continue to do that, and that's how today is going to play out. With that being said, what else? Jury charges.
Yes, Your Honor. I think we just have two quick issues to bring up with regard to what the defense's position is with final charges. We did send an email to the court yesterday afternoon with the one edit and the one addition. First of those would be to add within the element about bringing on the difficulty. Our position is that the language and the court's draft, the cleanest way to make this edit would be at the bottom of 16 going into 17, that if the conduct of the person defended or the defendant was unlawful and of the type which was reasonably calculated to and did provoke a deadly assault, and continuing from there. In support of that language, we're relying on State versus Bryant, 336 South Carolina 340. That's from 1999, and that exact language was reiterated in Slater, and that's 373 South Carolina 66. And the direct quote from those cases is that any act of the accused in violation of law and reasonably calculated to produce the occasion amounts to bringing on the difficulty, and would bar his right to assert self-defense if those conjunctive conditions are met. So that would be the first request that we'd have. And we also do believe that the evidence adduced over the course of this trial does squarely put the issue of withdrawal in front of the jury, and that is a question that they must decide whether. I don't think it's going to be any surprise that the state will argue that Andy Chow and or Rick Chow were at fault in bringing on this difficulty. With respect to the testimony that we have received over the course of last week, Andy's conduct, his act, the jury could find that act amounts to a withdrawal from any potential difficulty the jury may have found he had brought on. And if that withdrawal was effective, then his right to self-defense, and by extension, Mr. Chow's right to defend him, would be restored. And in support of that withdrawal charge, the language of which is one's right to self-defense is restored after a withdrawal from the initial difficulty with the victim if that withdrawal is communicated to the victim by word or act. And that or act portion was emphasized, I believe, in State versus McCarty. That's 437 South Carolina 355. And that is also quoting the Bryant case at 336 South Carolina 340. We do believe that the withdrawal law does need to be charged to this jury in light of what's been adduced over the course of last week.
Continue to state.
I just don't recall any testimony regarding any withdrawal. This was one continuous act, Your Honor. I don't remember any testimony whatsoever of withdrawal. It was a chase that went 130 yards, and there was some backing up that was testified to, but it was right at that moment. This was a bam-bam kind of situation, the way it was described.
Okay. Here's what I'm going to do. And I did look at all this. As far as the violation of the law language, I'm not going to charge on that. I think the implication of that charge would mean that there would have to be a violation of the law for someone to be not without fault. So I'm not going to put that in there. I am going to add the language of withdrawal. It is in the final charge. It will be on page 18 at the bottom. And here's the exact language. And it went a little further than what you asked for, Mr. Copeland, because I think you sort of cut it all short. Here's the exact language. One right to self-defense or defense of others is restored after withdrawal from the initial difficulty with the victim if that withdrawal is communicated to the victim by word or act, Withdrawal from a conflict must be effectively communicated to the victim by word or act to restore the right to use self-defense or defense of others. An accused who provokes or initiates an assault cannot claim self-defense or defense of others unless the person defended both withdraws from the conflict and communicates his withdrawal by word or act to his adversary. So, went a little further, then just, I guess you pretty much had the first sentence, but the model charge that we have added, that basically has to be essentially unequivocal that the person defended his withdrawal. So that's how I'm going to do it. Y'all have been emailed a copy of the final charge as well. Anything else?
Are you intending on, or have you thought about, we're going to send the instructions back with them initially, or just play it by
I
ear?
typically do not, and I will let them know that if they have a question about the law, the procedure for that would be to send me a note, and then I can recharge them on the law. I just get concerned that folks, this is intended to be interpreted as a whole, and I get concerned that folks, one person relies solely on page 17 and nothing else as a whole. I don't know whether I'm right or wrong. I know some of my colleagues send the charge back, but that's the way I am. All right, we ready for closing?
Yeah, a little PowerPoint here that's just going to have some, so it has the thing ready whenever. I know it takes a little time to fire up.
Okay.
I think this, we have it. Will it just turn right on whenever we're ready for the first line? We'll just-
It has a little delay.
Okay.
Yeah.
And you can call the document you gave me, did you give one to the court reporter? Did you mark this court on it?
I did not, Your Honor. I just passed it up to you, but I'll be happy to come up and hand
No,
it out.
we made this one, of course, tonight. All right, Rick.
Yes, sir.
All right, making sure, please, sir. Yes, sir.